Welcome to Oil and Gas Law with Energy Law Prof. Today we're talking about another constructive production clause, the force majeure clause. So the force majeure clause identifies circumstances that relieve parties from performing. And when we're looking at these clauses, keep a couple questions in mind. First, what kind of circumstances are going to excuse the parties from performance? Does the lessee have to let the lessor, landowner, know that there's a force majeure event that is preventing them from compliance with the lease? And what kind of performance is excused? Is this just going to extend the primary term so the oil and gas company has a little bit longer to drill? Is it going to keep the secondary term going even though a storm came in and knocked out oil and gas production for a period of time, so production has literally stopped? Is it going to prevent the oil and gas company from having to pay certain damages or otherwise? And then what remedy is provided? Does that mean, again, that the terms will be extended or that money payments will be excused, etc.? Now we can see these issues come up in Perlman versus Pioneer. It's a Fifth Circuit case from 1990. It's on page 271 in your book. In this case, Perlman has what he calls the Perlman process, which is just a way of getting natural gas out of coal formations. And basically, it's pretty simple. Actually, others have used similar processes, which is to pull water out of the coal seam where it's located, and then the natural gas will escape from the coal surface. And so this coal seam will be used to produce natural gas. And there was a big boom in this, especially in Wyoming in the 90s and 2000s. And Perlman says, I've got the best way to do this. And so he takes an enormous lease that covers both Montana and Wyoming. Now, in this case, Perlman is asking to get out of the lease. And you might ask, why is Perlman asking to get out of a lease? Because remember, oil and gas companies typically only have an option to drill. They don't have any obligation to drill. So they've already paid their bonus payment, and so if they want to walk away from the lease, they can just not pay a delay rental, or they can often surrender the lease. So typically, oil and gas companies aren't too desperate to get out of a lease. They typically just have that right. Well, the reason in this case is this is a special lease. It's a huge lease, and it's a relatively sophisticated lessor, landowner. And so the landowner negotiated for a provision that said Perlman had to pay $1.5 million to work towards development on this lease, and if he didn't, he had to just give the $1.5 million to the landowner. So why would you negotiate this kind of provision as a landowner? Well, basically, it assures you that that oil and gas company is serious about developing the property. So just like big bonus payment probably indicates that the oil and gas company is serious about the property, you could have this kind of structure where it says basically either you spend the money developing it, and I'm pretty sure that's going to go in to oil and gas production, that's going to pay me a royalty, or just give me that in addition to my bonus if you want to get out of the lease. Perlman doesn't want to pay that extra amount, and so he says, look, it's impossible to produce here because the state regulators have expressed skepticism about my process of production because of the water production. Okay, so what does the force majeure clause here say? It says the lease won't be terminated nor the lessee held liable in damage if compliance is prevented or hindered by an inability to obtain government permit or approvals. It also says that the lessee, the oil and gas company, has to notify the lessor in writing within 15 days of any force majeure, that's our notice provision, and shall use reasonable efforts to remove that force majeure. Here, the court says there was no hindrance to the ability to drill this well because the regulator didn't make a final decision on the viability of this process. Basically, they just asked for some studies. And besides, that was just one state, not the other state, since this lease covered both states. And by the same token, that means that Perlman did not not make reasonable efforts to remove that force majeure condition, and so therefore Perlman doesn't get out of the lease. Okay, when we look at these force majeure clauses, I think it's also important to know that these clauses as well grew up from a common law principle, which was a principle of frustration of purpose. If the purpose of the contract was frustrated, the parties might be excused from compliance. And that common law principle you see show up in interpretations of force majeure clauses sometimes. So for instance, in California, they say even if you listed an event like the government shutting down your well, that would be a force majeure event that would excuse performance or extend the lease. California says, no, we know this frustration of purpose principle, and it means that this force majeure event has to be beyond the control and contemplation of the parties. So something that they weren't expecting. Most states, however, view it just like any other contract clause. So the real question is this covered by the terms of the force majeure clause? Now, one area where it can get tricky is with the kind of government enforcement questions we see in Perlman. So sometimes government action really is like a completely freak storm that comes in and knocks out your well. And maybe it seems appropriate that that shouldn't result in punishment for one of the parties, that they should have more time to drill if that's what they need, that they shouldn't face particular damages from that unexpected event. But sometimes government enforcement happens that shuts down a well because the oil and gas company was violating some rules. So typically, if the oil and gas company was at fault in the government action that came and shut down the well, that's usually not going to give it the opportunity to rely on the force majeure clause and extend the lease.